The defense made a motion to dismiss their doctor from this case. What happens if the reasons for why they wanted to dismiss the doctor from this case is actually valid and appropriate? What happens if I don't do what they asked me to do, which is discontinue the action against that doctor? Want to know the answer? Come join me for a walk in downtown Manhattan as helicopters are flying overhead as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. So here's the scenario. We bring a lawsuit against various doctors claiming that they were careless and caused you significant harm and injury. During the course of the lawsuit, the defense attorney reaches out to me, who represents all of these doctors, and says, listen, doctor number 3 whom you sued has absolutely nothing whatsoever to do with the claims in this case. Doctor number 3's name was simply on the admitting documentation for the hospital, and they did not see the patient, they did not talk to any of the doctors, they had nothing whatsoever to do with this patient's care and treatment. Now, what if that's actually true? What if they now turn around and say, listen, will you voluntarily discontinue this doctor from your lawsuit? So now the defense attorney reaches out to me and says, listen, doctor number 3 did absolutely nothing wrong. There is nothing here to indicate that this doctor departed from the standard of care or in fact had anything whatsoever to do with your client's care and treatment. Will you voluntarily discontinue this doctor from your lawsuit? Now, if I say no, in all likelihood, the defense attorney is going to make a motion for summary judgment. Now, what's that? It's a formal written request to the court to take action, to do something. And in this case, that something would be to get this doctor out of the case. Now, what if there really is no basis to do that? Well, I will share something with you. At the very beginning of this case, before we actually started the case, we did obviously believe that there was a valid basis to go after doctor number 3. Our medical expert came to the conclusion that doctor number 3 was somehow involved in my client's care and treatment. But what happens, though, if during the course of the lawsuit we now learn that doctor number 3, in fact, had absolutely nothing to do with my client's care and treatment? And in fact, his name was simply listed as the admitting physician, although he had nothing whatsoever to do with my client's care and treatment. In that instance, when we learn new information, even after the case has started, now it will certainly alter and change our opinion. And now, after discussing it with my expert, if he comes to the same conclusion that yes, this guy had absolutely nothing to do with the care and treatment of this injured patient, there's no basis now to continue him forward. In that instance, the proper thing to do would be to reach back out to the defense attorney and say, you know what, you're absolutely right. Let's draw up the papers and get this guy out of the case. He doesn't belong in the case. If, for whatever reason, we turn around and say, listen, no, we still believe that this doctor does belong in this case for the following reasons, or not give any reason. When the defense makes their motion for summary judgment, if in fact we had no basis in fact to continue this doctor's involvement in this particular case, the defense could ask the judge to award sanctions against us. Why? For bringing a case against this doctor when we in fact had no basis whatsoever. So what the defense is going to do is they are going to show proof through a medical expert to establish that doctor number 3 had absolutely nothing whatsoever to do with my client's care and treatment. I am then required to oppose and rebut those arguments if I intend on keeping this doctor in. If I do not oppose it, and now I simply say, look, we have no opposition to this doctor getting out of the case, in that instance, the judge will likely let the doctor out. However, there is still the possibility that if the defense turns around and says that we had no basis initially to bring this case, and even after being alerted to the fact that this doctor did not belong in the case, we still continued to maintain him in the case. If that's true, the judge could, in some instances, turn around and sanction us for continuing to bring a case against a doctor that had no validity and no basis. And that's a position that I don't want to be in. So if there's truly a reason why this doctor does not belong in this case, our position most likely would be, okay, let's draw up the papers, get him out of this case, rather than forcing the defense to make this formal written request to the court and now running the risk that the court is going to fine or sanction us for keeping this doctor in, even though we had no basis to do so. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit but are thinking of doing so, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.